Good morning. Welcome to the Court of Appeals. I'd like to introduce your panel for this morning. To my left is Judge Davis from Knoxville. To my right, Judge Armstrong from Memphis. And I'm Judge Golden, also from Memphis. We have 3 cases this morning. I'm sure y'all are all aware of the ground rules. I would just say remind you that the plaintiff the appellant is entitled, both sides each have 15 minutes. The appellant is entitled to reserve up to 5 minutes. So if you would just make your request if you would like to reserve up to 5 minutes for rebuttal, and we'll grant that for you. Are there any announcements? Anything else? All right, you may call the first case.
Richard H. Niehaus et al. Versus Darnell Wade Houfek et al.
Good morning. I'd like to reserve 2 minutes, please.
All right.
Please, the court. I'm Douglas Spades. I represent the appellants in this case. They were initially served with a petition and filed a counterclaim and an amended counterclaim that was eventually dismissed by the trial court against the original petitioner and 2 other individuals brought into the case. Because it did not resolve all matters in controversy, this court entered a ruling denying a Rule 10 motion for appeal so the case sat dormant for several years. The underlying case has been resolved. The only issue now is this motion to dismiss. The best way, I think, to attack a pleading is to try, especially one involving a conspiracy, is to try to just take one little sentence of each paragraph and not put them together. So what I'd like to do is just tell the story that I believe is put well-pled facts into the pleading. This case involves property in rural Dickson County that a man named Michael Bresson attempted to purchase in 2017 with the express desire to put a gun range of his shooting club, Music City Tactical, on this property. He attempted to rezone it, and the rezoning effort failed for 2 reasons. First, the road in was not wide enough, and the road in was mostly on the appellant's property. Second, which was pled, was the neighbors did not want the gun range in their property. 2 years later, so Bresson did not purchase the property. 2 years later, the friend of Bresson's purchased the property. And after purchasing the property, efforts were done to build a gun range. Mr. Bresson continued to talk about this, continued to say work is on the gun range. Another individual came into the property named Mr. Brandon Stoner, who continued to talk about building a gun range. Eventually, there was enough of a gun range to have multiple days of shooting activity that the appellant complained of. But more than just having the gun range built, the appellees first widened the road under the petition for declaratory relief, which was countered with, this isn't a material increase on the burden of the easement. That issue was still left unresolved by the trial court's ruling. But it submitted that they...
Well, if you say it was unresolved, do we have a final judgment?
Yes, Your Honor. It's a little cumbersome. After the court entered its ruling on a motion to dismiss, we filed a motion, I believe somewhat seeking clarification on the court's ruling as to whether the material increase on the burden of the easement case still existed, and the court entered an order saying it does. Then, a year or so after that, a final order was entered with the 2 landowners, the Niehaus and the Houfek. So that's resolved. That's resolved. Okay. It submitted that the 3 individuals engaged in acts that drove the appellant's desire to fight for this property away. This included calling the police for no valid reason 3 times. Additionally, they cut trees on Mr. Houfek's property. And then I believe what I submitted is somewhat the seminal moment in January of 2020. Mr. Stoner tells Mr. Houfek, "At least when I go home, I get peace. You don't get any peace here." The next day, Mr. Stoner calls the police and tells the police falsely, "This gentleman has a gun." The police then detain him on that belief. It was pled that that was known to be false. It was submitted as false with the express purpose of humiliating, intimidating, and causing distress on Mr. Houfek. When the counterclaim was filed and then amended, all of these facts were put in. And the point of the gun range, I spent some time on the gun range, it's not like these acts were random. There was pled an express desire for a gun range to be built and for the neighbors to no longer complain about it. And so that was the reason these facts were pled and these causes of actions were submitted. There are 4 torts. First is nuisance. The appellants cite that there was a yard sale, that there was so much shooting activity that a yard sale had to be shut down and people left. Another time, there was shooting to such a degree that the appellant called the director of zoning for Dixon County for him to listen to it. And it was pled that the zoning director said, "Yeah, that's just not casual shooting."
Now, as you said a few moments ago, this was all occurring on the Niehaus's land, is that right?
That's correct.
And y'all have settled with the Niehouses.
That's correct. And this was a temporary nuisance. And in temporary nuisance, you request an abatement of it, as well as you were entitled to damages for the loss of enjoyment of life you occurred as a result of that temporary nuisance.
We're not talking about the Niehouses here, though, are we?
At all. That issue's been resolved. But I would say that the damage portion of a temporary nuisance is not an in rem proceeding. In other words, if you sell your property, you don't lose standing to request damages regarding what you occurred as loss of enjoyment of your property.
Damages against whom?
Stoner and Bresson. It could be Niehaus if he was still involved in the case. The facts pled were, again, that Bresson and Stoner both did work on the gun range that then invited the multiple days of shooting that eventually occurred. And that's the theories espoused before the court. The trial court said...
Well, in your pleadings, just as an example, with regard to Stoner, there's language that to the effect of that Stoner very likely was shooting on the property, as I recall.
I believe that was regarding the cutting of timber through his...
No, it was regarding shooting, I think.
I believe you're right. I believe the point was this man was...
Is that specific enough to say that it was very likely that he was shooting on the property?
I submit it was, Your Honor, that the standard in civil cases, preponderance of the evidence, it was Mr. Stoner had camped on the property. Mr. Stoner talked about doing work at the range, 100 target stands, things of this nature. The trial court, though, said you can shoot in a rural setting, which respectfully, under the 6 factors of West v. Luna, which talks about locality, character of the neighborhood, nature of the use, extent and frequency of causing the injury, the time of day, effects on enjoyment of life, health, and property. We submit that, this is not a situation of somebody zeroing in a rifle before deer season or shooting skeet before dove season or shooting a handgun. This is multiple people shooting in such a way that was offensive and substantially interfered with the appellant's use and enjoyment of property. For those reasons, on the nuisance, we think that it's well pled that a temporary nuisance occurred during the times of shooting. Additionally, the pled that timber was cut on the appellant's property without justification. The trial court did not analyze those facts at all. Then the last two torts, infliction of emotional distress and invasion of privacy, are somewhat related because there's some overlap of the facts. First was the multiple calling of the police. Every time a landowner was complained about the use of a neighbor, the response was to call the police, which, again, in and of itself, a citizen's entitled to do. If there's a purpose and intent behind it that shows it's for no valid reason, which is what the appellant's produced or in its pleading, at some point it crosses the line, especially when the day before the actual putting the appellant in the cop car, Mr. Stoner says, "I get peace, you don't," which I think speaks volumes as to the intent behind his actions. The appellees cite, well, you can make a report to the police. Of course you can, but you can't make a false report to the police. First of all, it's a Class D felony. Second, it goes to the nature of the behavior. It was pled that Mr. Stoner knew these facts were false. So for all of those reasons, Your Honor, we submit that these four torts were presented to the court in a pleading. We also took all of the desire of these three individuals to create a gun range, then put their behaviors in creating the gun range, and then the acts against Mr. Houfek that we submit amounted to torts and therefore show that the civil conspiracy was formed by the overt acts of each other.
Thank you.
Good morning, Your Honors. Russell Lewis with the Davidson County Bar. I have had the pleasure of representing Mr. Stoner for 4 years now. I've also had the pleasure of appearing before each of you before you were on this court, and I hope you don't hold that against my client. Context is important, and I want to point the court to the parts of the record that would provide the proper context and provide a little bit of commentary on that. Page 17 of appellant's brief, the section titled Argument, it goes through much of what counsel just said. It tells the story. Volume 1, pages 3 and 4 of the record, paragraphs 17 and 18, which were admitted. These were allegations that were admitted by Mr. Houfek. What happened here? This is neighboring landowners. To get to the Niehaus's property, you have to traverse an easement that is on the Houfek's property. The driveway goes down, Houfek's would turn off, Niehaus's would have to keep going, and anybody accessing that property would have to continue past the driveway on the easement that's on their property. What happened in this case is Mr. Houfek doesn't want what he anticipates is coming, and so he then, on the section of the easement that the Niehauses and anybody else would have to use, he then puts 5 gates up, cattle gates, that block the road. Not only that, as alleged, he puts debris on each side of the gates so no one can go around it. So if you want to go to their property, you have to get out and undo 5 gates. And what the record also shows is volume 1, pages 79, paragraph 71, is an account of what they allege Mr. Stoner was experiencing. Anytime he would come and go from this easement, or anybody, Mr. Houfek was out there giving them grief. And on that occasion, the record says that what happened, and this is the January incident that led to the calling of the police, what happened was Mr. Houfek slammed the gate on Mr. Stoner's car and trapped him in there. That's what the record says, and under the law, we're required to look at the complaint that was filed by the party. We're going to assume all those facts are true, and we're going to submit to the court, just like we did to the trial court, that all those facts taken as true don't constitute a cause of action against my client. What we've done here, what makes this case unique, and the roadmap I'd like to follow is go through the context, what makes this case unique, why the court should affirm it. And then I want to talk, if time permits, why I think this is a baseless appeal that's pursued solely to avoid the penalty imposed by law, which is if your claim gets dismissed on a Rule 12 motion, you're automatically liable for the other party's attorney fees up to $10,000. The underlying case is settled. There's no dispute between landowners about the use of this land anymore. This is all about the moment in time that we've talked about and what happens as a consequence of the case getting dismissed. So what makes this case unique? I'm a plaintiff's lawyer. I'm well aware of all the lingo we typically throw about from the cases, that the plaintiff's the master of the complaint. Notice pleading. Pleading should be construed liberally to do substantial justice. But that's not without limits, and that's what Rule 12 brings to this. Rule 12 says, fine, take that complaint as true, the words they chose, and in this case chose twice. First time this Rule 12 motion was filed, they chose to non-suit Stoner instead of argue it. They come back, throw in some Facebook posts made by other people, and then bring it back. We file it again. The court analyzes the entire complaint and the arguments that were made, and the court determined that under none of the theories was there a cause of action that could be asserted against Mr. Stoner based upon what was alleged against him. Now, where this gets a little bit crafty is that the cake is baked, but on top you have the icing, which is the conspiracy theory, which means even if Mr. Stoner didn't do something, he's potentially still tied to what the other people were doing. But as pointed out to the trial court, conspiracy requires knowledge and intent. And there's nothing pled, no facts pled, that would allow a court to conclude that Mr. Stoner had either the knowledge, much less knowledge and intent of any conspiracy to commit an illegal act or a legal act for an illegal purpose, which is what the law requires.
Talk to me about the conversion claim, about the cutting. This is involving the cutting down of the trees. I think.
And Your Honor, when you asked this question earlier, I think there's some conflation with the record. The record says that it was very likely a company owned by Mr. Stoner that cut the trees in October of 2019. The record on the brief anyway claims Mr. Stoner was a shooter, but that's incorrect. There's nothing about him shooting in the record at all. It's a misstatement called an omission, but the conversion. One, there's not an allegation that Mr. Stoner converted any property at all. That's just not in there. There's argument that says that, but that's not an allegation. What it says in October of 2019 that somebody's out there marking Mr. Houfek's trees, and that some are being cut by somebody that's likely from a company that's owned by Mr. Stoner. That's almost verbatim what it says. And I'll submit to the court that under Rule 8.05, that's not anywhere close to adequate. Rule 8.05 requires that each averment shall be simple, concise, and direct. The appellant in their reply brief says that 8.05 allows a party to make alternative and hypothetical arguments. That is true, but that's not the context where you can do it. You can't say hypothetically it was you. What the hypothetical is in an answer, hypothetically, if I did this, then I didn't cause the harm. That's where that comes into play. A hypothetical is you know, hypothetically, if this continues, then I will suffer this damage in the form of an injunction or something like that. But it's not, hypothetically, you were the person who did this. So there's nothing that says Mr. Stoner converted any property. Moreover, when it comes to conversion, there's nothing in the complaint that says that any of the trees cut were not on the easement. And it's undisputed that they had a right to use and maintain that easement. You know, Mr. Houfek owned the entire easement. So any tree that was cut on the easement is technically his tree. So to the extent that that's even possible, it's not well pled at all, I would submit. And the burden is on them to plead those facts. And that brings me to the next topic that I'd like to address. The record's full at the trial court level and this court. The record contains, I won't say full, but there are numerous inaccurate statements about what is in the record. The record is simply not as represented in the appellant's briefs. For example, the briefs claim that Mr. Stoner, that all parties were involved in shooting, that the complaint says all parties were involved in shooting. That's not what the complaint says at all. There's nothing in the complaint that says Mr. Stoner was ever shooting a gun or was even at the property when guns were being shot. Mr. Stoner did go to the property, but there was never an allegation that he was there during those times of nuisance. So that's a misrepresentation that I hope the court is clear about. There are others. They're outlined thoroughly in my brief. You know, and we believe that those misrepresentations, along with the reasons we've cited in our brief, warrant this case to be affirmed. None of the individual torts, the elements just aren't met. There are elements missing with regard to all of them as outlined in the brief. And this is a case where we're now on our, our amendment, and it's still not right. All this leads me to conclude that, this is an appeal that was taken to delay the matter and to avoid the sanctions provided under the statute. And we would ask the court to affirm the judgment.
Thank you.
Thank you.
Just a couple of points.
You have 2 minutes.
First, it was not to delay the matter. That's why I sought Rule 10 application, because when you have multi-party cases, a final judgment on one, but the trial court didn't certify it, so we sought appellate review as quickly as possible. Number two, it's far more than just adding some Facebook comments. From the initial counterclaim to the amended counterclaim, multiple statements, especially of Mr. Stoner, that were gathered during the discovery process were put into the complaint. I want to read from the pleading, paragraph 62 through 65. Again, Mr. Stoner, their position is he's just a humble person there cutting timber for no reason, has no input on this. On February 10th, 2020, Stoner traverses the easement with a bulletproof vest strapped on and an AR-15 or some other semi-automatic weapon in hand as he exits the vehicle to open the gates and breasts and posts, building 200 target stands, 100 wall sections, and 60 barrels will be delivered to the property within a week or two, going to start shooting there soon. This is hardly a range expecting a single landowner to sight in his weapon before competition shoots. This is a setup for a large gathering, allowing for hundreds of targets and sections in which to shoot high-powered weapons. February 20th, Bresson and Stoner state they're milling trees for the wind, and on Saturday, February 22nd, extensive gunfire can be heard. if Stoner helps the conditions set for the February shooting, whether he was shooting the weapon or not, he's still responsible for creating the conditions that created the temporary nuisance. And that's why he's sought in this case.
Yeah, let me ask you, in connection with the complaint regarding the destruction of trees, what are your allegations in the complaint against Stoner and Bresson?
First, the allegations were not that it was on the easement. The allegations in the complaint were it was on his property.
Can you read that to me? What does it say specifically? Do you know?
On October 15, 2019, Niehaus, along with Bresson, had trees on Houfek's property spray painted orange, and the trees belonging to Houfek were being cut down by a tree trimming company, very likely Timbersmith X, owned by Brandon Stoner, a shooting partner of Michael Bresson and an MCTS Gun Club member. Dispatch was called against Houfek as this was vandalism to his property, although to Bresson, as referenced in paragraph 31, it was only phase 1 of his plan to start dozing the property for trees to be cut and bays to be marked. There's one other paragraph about conversion I can also, it's paragraph 76.
Go ahead. And does it make allegations against Bresson and Stoner? This additional paragraph you're going to read to me.
The allegation against Stoner, it was in paragraph 47. The allegation was taken in part of the entire pleading, which is all three of these individuals had a vested interest in creating a range. They discussed it. All three of these individuals did work on this range. It was submitted that there was a timber company that we submitted as very likely the one that cut this property on the appellant's, the trees on the appellant's property.
They're not a party. The company's not a party.
The company's not a party, that's correct.
Okay.
Thank you very much.
Thank you very much. We'll take your case under advisement and render an opinion as soon as possible.
Thank you, Your Honor.
Thank you. Please call the next case.